Thank you, Right Honourable Speaker. First of all, I want to express gratitude to the Attorney General that he was able, unlike the tweets that we saw, which clearly said that these suspects, or some of them, would not be released, at least the Attorney General has indicated the willingness to have the court order implemented, notwithstanding, of course, instances where he must have read these orders upside down. Right Honourable Speaker and Honourable colleagues, as the Attorney General was communicating, I have been really touched and concerned about a number of issues. The Attorney General knows very well that a person can only be held in prison on a valid warrant. The order of court, which literally dismantled, and I mean literally, not technically, dismantled the orders of the defunct court-martial, caused the warrants upon which these people were remanded to expire. But in the case of retired Colonel Dr. Kizza Besigye and Haj Obeid Kamlegea, even without the orders of the Supreme Court, the warrant itself was expiring on Monday, yesterday, and it did expire. So, my question to the Attorney General, currently for these people or persons that are being held, on whose orders, on whose valid warrants do they continue to be in prison? The second, Right Honourable Speaker, relates to the DPP liaising with the General Court Martial. What is the DPP's business? The DPP is empowered under the law to commence prosecutions against any person of her choice, provided there is evidence she has before her. The reverse is not true, that the DPP goes around fishing for cases. Number three, Right Honourable Speaker, but this time they are telling the DPP to be the one to go around fishing cases from persons that have been conducting business illegally. Do not forget that until Friday 31st, there was a decision of the Constitutional Court which declared that this is not a court of law. So whatever they have been doing, they secured an interim order from the Supreme Court, and the order was to stay execution. Execution in this case was purely the transfer of files from the General Court Martial or from the Courts Martial to the civil courts. You could not stay a declaration. You can't stay declaration. That declaration, that interim order, was used by the General Court Martial, not DPP, to continue and to commence fresh prosecutions. Thirdly, Right Honourable Speaker, from the Attorney General's communication, I have not even heard anything to do with timelines. Timelines, so as long as they are doing their consultations, these people can be in prison now on orders of the Attorney General. Where, under the law, does the Attorney General get the powers to remand or continue an illegal remand or to detain? Literally what he has done is to amend the orders of court. Finally, I received information from the Honourable Semeju.
Thank you very much, Honourable Medad. Thank you, Mr. Speaker. The information I wanted to give to Honourable Medad and Parliament is that yesterday our lawyers who represent Dr. Besigye and Haj Obeid visited the Commissioner General of Prisons. And he said his understanding was that people needed to leave, Besigye and Haj Obeid needed to leave his prison on Friday when the judgment became effective. And he said he was there seated waiting for the Attorney General. Up to yesterday, the Attorney General had disappeared from him. The last time this happened, the last time people were in Ruzira on no warrant was after the fall of Idi Amin. I interviewed Brigadier Ssegona when I was a journalist. And he said they were driven to Luzira, and they were told, you go there, the warrant will come. So effectively, I didn't know that things that were done by soldiers and after can be done by Honorable Kiwanuka Chiriowa almost 40 years later. That's the information I wanted to give you.
I thank you for the information, apart from the last one, which was not information, relating to what you did not know that Honorable Kiwanuka can do. Right, Honorable Speaker, I do not want to end at criticizing and critiquing my brother. I think I want to give some way forward. If I were in his unenviable position, this is what I would do. From Friday through to Monday, I would not sleep. I would require the information from the General Court Martial relating to all prisoners that are held on orders of the General Court Martial, now deceased. From that point, I would advise government to sieve out all political prisoners, matters which are not pure crime, and say, let us go and do the honorable thing of withdrawing. That someone can continue to be in prison, and the Attorney General is busy advising on somebody who was putting on a beret, a red beret, whether he should remain in prison. The third thing I would do, and for more than 4 years now, third thing I would do is to advise the police to immediately approach the General Court Martial, obtain all those files where we feel it is pure crime, a suspicion of crime, not suspicion of politics. Then I would advise that police would get those people from wherever they are upon release. But for you, you cannot say you are complying with the court order without releasing these people. At least do the ugly thing you've been doing of arresting them at the entrance or exit of the prison, the same way you've been arresting them from court. But any continuity in detention is illegal. Finally, I am concerned as a leader in this country. Immediately upon release of the judgment, Colonel Chris Magezi, who is said to be an assistant to General Muhoozi Kainerugaba, issued a statement which he called the official statement from the UPDF. And it was clear and categorical. They shall not be released until General Museveni, the commander-in-chief, gives us orders to release them. And that is the basis upon which we challenged the constitutionality of the court-martial, because it is dependent on orders of the chairman of the High Command, who is General Museveni. Membership includes his son, who is now tweeting to say we cannot release. Mr. Speaker, for how long are we going to continue like this as a country? You have a dignified Attorney General. That man knows the law, by the way. Even when he chooses to disobey or to ill-advise, at least he knows the law. Now, we receive another statement from the president. Half of it was dignified. The second half was very dignifying. You hear from the president, and what he says that this country is not governed by judges and lawyers, where I agree. But this country is governed by a constitution. Anybody who does not want to obey this constitution should give us our peace by leaving. I am concerned about the tweets of General Kainerugaba. You saw when he said that he was going to attack the mercenaries in Congo. A few days later it happened. How are our neighbors going to take us? You crack a war inside, you crack a war outside. Why? Is it the constitution, Mr. Speaker?
Thank you.
Mr. Speaker, first of all, the court-martial cannot sit. So it cannot sit to make any orders that you want them to make. That's one. Number two, if there are facts that you have, Honorable Medad Ssegona, as a senior lawyer, if there are facts like you have stated here, the best place to take them is to the court. Yeah? Yes. Secondly, Right Honorable Speaker and Honorable colleagues, Honorable Ssegona should know that as a practicing advocate, after you are successful in court, you extract a decree. If you think my advice is inconsistent with what the judgment said, you should at liberty to extract a decree, have the court sign it, and use it in the premises that you would like to use it. I have read this judgment variously, and you may think that I was sleeping. I did not. I spent time reading this judgment page by page, and I word for word. And what I have advised here, I did not get from my head. I got from the judgment. The matter under discussion is not the Court of Appeal decision. The matter under discussion is the Supreme Court decision. So reference to the Court of Appeal decision which was appealed against is misplaced. Now there are no timelines. I agree. But we have sent the matters to the courts which granted these orders. The courts are still clothed with the authority to make any orders that they deem appropriate. Like
Point of order.
You see, Right Honorable Speaker, when the Attorney General speaks, he's the head of the bar. Everybody at the bar ordinarily should keep quiet. I agree with him that a successful litigant goes ahead together with the losing litigant to sign a decree, to prepare a decree jointly. If he was waiting for a decree, what was the basis of his advice? Number two, I am not aware, and he can now educate us, the law under which a losing or vanquished litigant would write to court to ask for which orders. The orders, Honorable Nwagaba says, is self-executing. Is the Attorney General therefore in order to mislead both the House and the country that the person who was in court when the judgment was being issued is waiting for a decree extracted by one party?
Attorney General, you want to make some clarification, if I can guide?
Right Honorable Speaker, I think where we are going here is a bit of a runaround, because I have told you my understanding of the judgment. And yes, and that's why maybe I lost. But what we are saying is that if you disagree with what I have written as what the court said, the arbiter is there. Now, finally,
firstly, I'm glad that the Attorney General has correctly advised the executive to implement the court order. That's a good thing. However, I think that the learned Attorney General is misadvising the General Court Martial. The insinuation in the remarks of the Attorney General is that Court Martial keep holding on to these people until the DPP determines whether or not to take over this matter. I think that that's ultra-vires. Because for all of these people who are being held, Dr. Kiza Besigye, Obed Lutale, NUP political prisoners that have been held for over 4 years now, the Supreme Court said all those matters under the court martial should cease with immediacy. Now, Article 120 of our country's constitution, which provides for the office of the DPP, when you go all the way to number 6 under Article 120, it says that in the exercise of their authority, the DPP shall not be under the control or manipulation of anybody. So nobody is meant to give any order or directive to the DPP. What the learned Attorney General seems to be saying is that now the court martial is going to be directing the DPP to say, we have these matters, you take them up. That's against the law. What's meant to happen, Right Honorable Speaker, is that the court martial is meant to issue with immediacy release orders for these people, because the court martial no longer has any authority over these people. Completely release them, and then the DPP, in her choosing and in her investigations, if she determines that maybe there is any matter that's meant to come before the civilian courts, that can happen. But you see, the two courts are disjointed. Honorable, there is some information, if you'll allow, from...
In just a second, Right Honorable Leader of the Opposition, they have actually, from the communication of the Attorney General, they have actually already interfered with the independence of the DPP by telling her to go and liaise. So it is not that the DPP is not under control. They have already controlled her by telling her to go and liaise with the court martial.
Thank you, Council Ssegona and the Attorney General. Mr. Speaker, sir, this particular judgment falls in the category of what we call self-executing judgments. It's a judgment that should be complied with without any other process as alluded to by the Attorney General. Actually, if I were the Commissioner of Prisons, I would have released all those individuals mentioned in the judgment, including the UPDF officers undergoing trials in the General Court Martial in respect of offenses tried by civil courts. And then, as you normally do, you would arrest the people outside the prisons, take them to police, detain them for 48 hours, charge those you can, make fictitious charges against those you can, and do the like. But I think, yeah, otherwise, other than that, what is happening, Right Honorable Speaker, and the Attorney General agrees, is that all players, especially the prison warders who are detaining these people, are doing so illegally. We are literally doing so in utter disregard of the constitutional provisions. So we have overthrown the Constitution. But be that as it may, Mr. Speaker, my worry is in what is actually being planned by the government. Because the information we've got is that they are now trying to come up with a bill to overturn the Supreme Court judgment. And that is the reason why the Attorney General has advised a series of procedures to be taken, which he himself knows are inherently illegal. So, Mr. Attorney General, sir, my learned friend, don't put my brother Yawashija, the Commissioner of Prisons, into problems. Because today, after here, we will advise the affected persons to take out contempt proceedings against him as an individual. And he will not rely on our advice, because this particular judgment is self-executing and does not envisage you to advise them to do anything to the contrary. So just advise the man to release the people, send your police to arrest them outside the prison gates, and then begin the processes if you so wish.